Hello and welcome back to All About Community. Again, my name is Robert L. Harris, and I am your host. I'm speaking with attorney Vernon Goins, who is a local lawyer here in the Bay Area, and we were talking about estate planning and the importance of it. Is there a difference between a will and a trust?
Yes.
Okay, explain that so
Okay.
people will understand.
All right. So with a will, a will is a document that that will describe a variety of things. Number one, who would be in charge of making sure that your distribution plan is met. So that person sometimes is referred to as an executor or a personal administrator. Then in the will, you have a distribution plan. So those who are to receive under the will, these are the beneficiaries, heirs, devisees of the will. And then finally, you have the person who sets up the will, and that is known as the testator. A will must be witnessed by two people over the age of 18. The person who prepares the will, the testator, of course has to be someone who is competent. And then what happens is the will does not actually start to go into place or doesn't become into effect until someone dies or passes away or transitions. And then at that point in time, the will needs to be probated. So it goes through the courts. The court has to sign off on making sure that whoever is nominated as the executor, personal administrator, does what he or she is supposed to do.
What if you want to write your own will? How's that done?
Well, there's a few easy ways. So you can simply just take a piece of paper and just say, I give everything to such and sign it. That's called a holographic will.
Holographic, right.
So wills don't necessarily have to be typewritten. Okay. A trust is different.
Okay,
So
let's talk about a
trust is designed to
wait
make
a minute. Before that, with the holographic will, do you need signatures on that as well?
the testator needs to sign, but you don't need witnesses.
Okay.
Okay. So with a trust, it's different. So unlike a will that has to be probated, that has to go through the courts, a trust is supposed to be designed where you don't go through the courts. You have a trustee who is supposed to take care of the administration and the orderly distribution of a person's estate or the trust rest outside of court. A trust doesn't need to be filed anywhere. A trust is in many instances private. So you have something that's called a revocable trust. That's something that you can change during your lifetime, so long as you have the capacity. And so at least with the advantages of a trust is that it's private. You're not supposed to go to court. You can prepare it any way you want to.
Supposed to go to court.
You're not. So there are disputes. Okay, so there are disputes that come along that challenge, in some instances, the validity of a trust.
But you usually have a provision in there to deal with them. Is that right?
Yes, and so in some instances you can have protections against that. There's something that's called a no contest clause that basically says that if someone challenges the will, because claiming that it has been forged or it has been the trust because it has been obtained under duress, fraud, undue influence, or anything of that nature, is that they are sometimes given $1 or sometimes given nothing at all.
Yeah, the typical one is that if you contest it, you get $1.
Yeah, but also another great thing about the trust is it doesn't start to operate until doesn't have to wait until someone dies when it starts to operate. With a trust, if someone becomes incapacitated,
right.
Or let's say, for example, they voluntarily say, well, I'd like for my granddaughter to handle my trust, handle my affairs. I'm tired of writing the checks, and I'm trying to tired of doing things on my own. It can be done voluntarily.
And that's so important. A lot of people just seemingly they don't even think about it. I think I know what it is. They don't want to think about dying, and therefore they don't want to deal with these kinds of situations, so they just ignore them. But it's so important to deal with these situations while you are alive, because if you die, then it's going to be holy hell.
Right. And your own mortality is obviously something very difficult to deal with and appreciate and really understand. But ultimately, at the end of the day, estate planning is really about life, okay? It's about protecting those people who you want to receive your property. Because ultimately, at the end of the day, the more orderly, the smoother it is as it relates to the transfer of your assets upon your passing or upon the happening of an event. That, in fact, you can do a variety of things with that. It's such a great power to be able to influence the lives of not only just your children, your grandchildren, but there are trusts that are even set up to give to charities.
And that's important. Unfortunately, we got to go to break, so don't touch that remote. We will be right back. My name is Robert L. Harris, and this is all about community, and I'm speaking with Vernon Goins, who is a local lawyer right here in the Bay Area. We will be right back, so don't touch that remote.